Justice Madlanga, I do believe that all parties are online, including all the judges. May I ask the registrar clerk to call the case? You're on mute, Justice Madlanga.
Thank you, Justice Theron. Yes, please call the case, registrar clerk.
Good morning. I'm the registrar clerk for this hearing. Justices of the Constitutional Court, all counsels are online. I call the matter of Beggar N.O. and others, and Bester N.O. and others, and Bester N.O. and others, and Quintado 120 Pty Limited. For hearing, counsels are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please the court, I appear on behalf of the HNP Trust in the HNP Trust application, and on behalf of Quintado 120 in the Quintado 120 application as a on behalf of the respondent, together with my learned friend, Mr. Bagley.
Thank you very much, Mr. Van Eerden.
May it please the court, I appear for the insolvency trustees, that is Bester N.O. and others, in case number 246, as well as case number 160, as respondents in the first matter and as applicants in the second matter, together with my learned juniors, Mr. Watt and Ms. Adhikari.
Thank you, Mr. Van der Merwe. Yes, Mr. Van der Merwe? I'm sorry, Mr. Van Eerden. Mr. Van Eerden.
As the court pleases. This matter, the HN is the application for leave to appeal by the HNP Trust against the judgment of his acting justice Sievers, where he granted a final order of sequestration against the trust. The first issue, which we will not address in argument, subject to what the court requires, is the matter of whether the condemnation should be granted. We understand that the respondent does not oppose condemnation, and the case of condemnation is set out in some detail in our heads of argument as well as in the application. Under the circumstances, once we have addressed the court on the merits, we would submit that condemnation. It would be appropriate to be granted under the circumstances. With regard to the second issue, as we see it, the question as to whether we engage the jurisdiction of this court under section 167(3)(b)(2) of the Constitution, we submit indeed that there are arguable points of law of general public importance, which this court ought to consider. And in this regard, we intend to deal with those points as points of arguable points of law, but also about merits at the same time, in order to save time and to make sure that it is a proper address. The first point that we say is an arguable point of law is the point that relates to the amount, cause, and nature of the claim which is advanced against the HNP Trust. In other words, what we say, it is the issue of locus standi. And the reason in this matter why it is an arguable point of law and not only an issue of fact is that, inter alia, the respondent says in paragraph 85 of its heads of argument, of their heads of argument, that the Kleinans case means that you don't have to make out a cause of action as long as, or it doesn't matter what cause of action you make out, as long as you have a liquidated claim, which you've proved. Now, we say that is not correct. And we say that the authorities are to the effect that one has to make out your claim in insolvency. If you want to obtain locus standi, you have to make out your claim in your founding papers, of course. And not only do you have to make out your claim in your founding papers, but you cannot supplement your claim at a later stage. Now, what has happened in this matter is the original claim was advanced in the application on the basis set out in the founding papers, and it is common cause now, I think, that it was based on false facts. The false facts related to a meeting of 13 December of the previous year, and in respect of that meeting, it was alleged that Mr. Lowe, who was then not a trustee anymore of the HNP Trust because he'd been sequestrated, had stated at the meeting that there was, in fact, and if one reads the founding papers, what they say is that the trust, that the Mr. and Mrs. Lowe have a claim, effectively a loan claim against the trust, because funds were advanced by Mr. Lowe to the trust and to Falaco, his company, in turn. As it turns out, and as we point out, and one can, in the record, one can read precisely how it occurred in volume 3, where Mr. Cronje's answering affidavit sets it out. In fact, what happened at the meeting was quite the opposite of what was alleged. And in fact, the evidence which was relied on in the founding affidavit was admittedly false. And in fact, Mr. Lowe said the opposite of what was contended. He said that it should never have been reflected in the books of account that there was a loan between Falaco and the HNP Trust. And as a result of that, of course, no loan as contended in the founding papers could have been entered into between the trust and Mr. and Mrs. Lowe, or Mr. Lowe in any event. So the whole basis upon which the application was brought, the locus standi, disappeared in our submission by the time Mr. Cronje, who made the answering affidavit eventually after the fellow trustees were appointed, did his supplementary answering affidavit. His supplementary answering affidavit set out that no funds were ever advanced and that there was no loan agreement because the co-trustees had never agreed to the loan agreement and had not authorized the entry into any loan agreement. As a result of that, we submit in the written argument that that should have been the end of the matter, because there was a clear dispute as to the veracity of the claim that was advanced. Not only was it a dispute, but the balance was in favor of the respondent, clearly, because the applicant had admitted that what it had relied on was false, and in fact it had tried to explain the false evidence by referring to other events that had occurred before that. What it was left with in the end, effectively we submit, was contradictory versions by Mr. Lowe as to the cause of action. And later in the proceedings, the trustees abandoned the whole purported basis of the original claim by saying, well, they never intended to say that funds were actually advanced. They were talking, there was at best, there was a cession of a loan. No talk of that can be found in the founding papers. And we say the effect of that, we submit, is that the applicant is not entitled at a later stage to try to restore its case by making out a new case for locus standi. And we say so, and the reference is in our written argument, particularly on the basis of the case of Moodley versus Kasim, where the debtor came to court on a debt which was based on some checks of £200, but the credit, I apologize, the debtor, the creditor came to court on the basis of checks of some £200. The respondent submitted proof that the indebtedness under the checks was only £40. He did say, however, that he owed the applicant another sum of £200. The court said, well, there was no replying affidavit filed. And the court said, well, one must look at the provisions of Section 9 and Section 12 of the Insolvency Act. And the court says, I have no doubt that a petitioning creditor is confined to the claim, the amount, cause, and nature of which is set out in his petition, and it will not avail him if it emerges from the affidavit of the debtor or otherwise that the debtor is liable to him in respect of a claim or claims not relied upon by him in his petition. And we say there's very good reason for that rule, because the effect of sequestration is immense in relation to particularly individuals who are usually the subject of sequestration proceedings in insolvency, in the sense that their status is affected extensively. And everyone will understand, for example, that an insolvent is not allowed to be.
Mr. Van Eden, the 10 minutes is up. You capture, according to you, the point of law centers around locus standi. Is the law settled on that?
Well, Lord, I apologize, Justice. I think the law is settled on that, except insofar as the respondent contends that there is a difficulty with the general contention. At paragraph 85 of their heads of argument, they say that in any event, if you look at whether the claims arising from the application of misappropriated funds are loans or based on any other ground is with respect legally irrelevant. And they say that is so because of the case of Kleinans versus Van der Westhuizen. We submit Kleinans versus Van der Westhuizen appears perhaps on the surface to say so, but doesn't hold that. And Kleinans versus Van der Westhuizen cannot stand if one has regard to the authorities relating to locus standi. In particular, it's not only the authority which I referred to, there are further authorities, Center Enterprise versus Bronieri, 1972, 117, and Rulo Barry Beperk versus Boschen, another 1967, 154, that's 60 to 61B. And those authorities hold the same, namely that if you come to court with a cause of action which is described in your founding papers, and you cannot sustain that cause of action, you cannot attempt to adduce a further cause of action or another claim.
You use what the respondents say in their submissions as your springboard to the engagement of our jurisdiction. Your client was first to approach this court. In your client's case, standing all on its own before we had anything contained in paragraph 85 of the respondent's case, what was the arguable point of law of general public importance? Because at that stage, you could not factor what the respondents are saying in their written submissions. Mm-hmm. Should I take you to where I think the essence of the applicant's case is captured in your written submissions? Paragraph 101 of your written submissions. Are you there?
As at page 40, Justice.
Page, yes, you are. Yes, Mr. Fan. Yeah. Does the first sentence of that paragraph capture the essence of the applicant's case or the substance of it?
Justice, we do not contend that is the basis on which the court's jurisdiction is engaged. the court's jurisdiction is engaged if one has, in our submission, regard to all the issues that were raised in the quota quo. And one of the issues that was raised in the quota quo, and this issue of Kleinhans versus Van der Westhuizen was raised there too, in argument. One of the issues that was raised is that the applicant tried to adduce evidence and reply relating to other causes of action. And those other causes of action it tried to sustain by referring not only to new matter, but also referring to, or attempting to refer to, a Section 152 inquiry, and also by simply stating that there is further evidence about the cause of action. Now, all the evidence that the learned justice, acting justice in the quota quo took into account, we've dealt with in our heads of argument. But we say that the point of law that is arguable and important and needs to be reiterated is that the cause of action is in all respects to be contained and defined in the founding papers, and there's very good reason for that. And we say in this case it arises because the respondent has attempted throughout to change tack, or change course in its papers, and to present other causes of action. And that
let's look at the 3 points that you raised as arguable points of general public importance, which this court ought to consider. Let's go to your heading at page 23 of your written submissions. What is the insolvent estate's claim or cause of action? I would imagine that's pretty mundane and, if not pedestrian, and it relates to ordinary principles of the law of insolvency. Nothing jumps out of the page and says the Constitutional Court must consider this. And then your argument on this starts paragraph 43 and it goes all the way to paragraph 61. The only little bit of legal argument, if not a mere statement, not really argument, a statement of, again, settled principles is at paragraphs 55, 56, and 57. The rest of those paragraphs from 43 to 61 is facts, facts, facts all the way through. And let us look at the law that you raise in paragraphs 55, 56, 57. All of that are settled principles. How does that raise an arguable point of general public importance, which we ought to consider?
Justice, I think that my submission in that regard is that the manner in which the law may be settled, but the manner in which the law is applied in the circumstance of a particular matter is also a matter of it can also constitute an arguable point of law.
Then every case would come to the Constitutional Court if that's the basis. We would be the final court of appeal in everything.
We do, however, also, Justice, refer to other arguable points of law in our written submissions.
Yeah, you have the remaining two, and my observation with regard to those two as well was similar to my observation on this one, but I do not wish to take up too much time. My colleagues also still want to engage you. I'll just leave it at that, but I'll say I made similar observations with regard to the two remaining points as well. You may respond if you wish to.
As the court pleases. With regard to the other issues, we submit that the arguable point of law in relation to the trust and its representation is mostly in relation to the court's finding of acquiescence and apparently the apparent reliance on acquiescence as a basis for finding that Mr. Lowe was authorized to enter into loan agreements with on behalf of the trust in the first place, with Falaka on the one hand and with Mr. and Mrs. Lowe on the other hand. That, we submit, is an arguable point of law because of the fact that the authorities, and other than the Grainco case, which is an outlier, so to speak, the authorities are to the effect that one must look at the terms of the trust deed, and the court did not look at the terms of the trust deed in attempting to find that there was an authority for Mr. Lowe to enter into loan agreements at all. Our submission is that the arguable point of law and the important point of law is that the case of Grainco, as we say, was not based on the law, but that the law, if applied to the circumstances in this matter with regard to the ability or the representation of trusts, has been controversial in the sense that there is a general feeling in the authorities expressed, and particularly in some authorities, that there's a discomfort with the fact that trusts are represented only jointly, effectively, and there is a reference to other ways in which trusts may or may not be held liable, even though the trustees have not acted jointly. With regard to what the specific arguable point of law is, in our submission, it would be that the acquiescence or the alleged acquiescence of the trustees to the actions of Mr. Lowe could not in law establish that the trustees acted in accordance with the terms of the trust deed in this matter. And if it doesn't do so, there's no basis upon which to find a general authorization, or indeed what acquiescence might mean under the circumstances of this matter.
Mr. Van Eeden, I have two questions, one on jurisdiction and the other one on merits. On jurisdiction, there's factual disputes surrounding this matter. Now, how can we then say that this court will have jurisdiction under those circumstances?
Justice Mtlantla, the basis upon which we rely for the engagement of this court's jurisdiction is, as I've submitted with regard to the first point, and as I've set out in the argument, with regard to the second point, we say also that it is a matter of law and an arguable point of law of importance to determine, and for this court to engage in the debate in relation to the way in which a trust acts, or in the way in which a trust authorizes a particular trustee to act. Under the circumstances of this matter, we say that in law, the finding relating to acquiescence is a strange finding, and it has resonance in relation to the law of trusts and the representation of a trust under different circumstances. But of course, I must concede that factually, the finding of the quota quo is flawed, because we contend that there is no knowledge by the co-trustees, and in fact, on the facts that there was no knowledge of the co-trustees of the actions of Mr. Lowe, and therefore there couldn't be acquiescence. So yes, on the one level, there's a factual failure of the case, but there's also a legal issue which we say is worthy of consideration. With regard to...
Now, when you deal with authority, at para 96 of your written submissions, you state that the agreement between the trust and Mr. Kellerman does not amount to a collusion. Which of the trustees were authorized to conclude this transaction? if it was Mr. Cronje alone, did he have authority to do so?
Justice, I'm sorry, I didn't understand what you're referring to. What paragraph?
Para 96 of your written argument.
96.
You deal with the issue of authority.
Yes.
About the collusive transaction.
Yes. Well, we say the collusive transaction is with respect to a red herring in this matter. The collusive transaction that they are alleging was a transaction that was carried out between Mr. Cronje and Mr. Kellerman post sequestration of the other trustees, on the basis that Mr. Cronje had no authority, and that we say must be so. That agreement that was entered into cannot be a valid agreement, and that was conceded on behalf of the parties that I've represented in an event some time ago. The question relating to whether or not that agreement is valid, that agreement could not have been entered into, we submit, on behalf of the trust by Mr. Cronje only. Clearly not, because he was disqualified and he was not authorized by any, on the facts of that particular authorization. There was an authorization on the resolution that was taken by the trustees when they were all still in office, but that resolution enabled Mr. Lowe to sign documentation, not Mr. Cronje, and the agreement was never effectively put into effect, and the agreement was never effectively reduced to writing when there were still trustees in office, or 3 trustees in office. So the agreement which creates the obligations on behalf of the trust was never reduced properly, and we concede that when Mr. Cronje in December made an agreement with Mr. Kellerman purporting on behalf of the trust, that agreement must fail because of the lack of authority.
Thank you. So the only issue then remains would be the authority of Mr. Lowe.
Yes, the issue is with the authority of Mr. Lowe, as well as the authority or lack of authority of Mr. Cronje when the provisional order was taken. And we contend that on both those, in both respects, Mr. Lowe and Mr. Cronje did not have authority. Mr. Lowe didn't have authority to enter into agreements of loan, and Mr. Cronje didn't have authority to litigate at the time of the provisional order, although that was not his reason for staying out of the litigation. His reasons were different. But the fact of the matter is that he wasn't authorized at that stage, or he didn't have the powers to oppose the sequestration application at that stage.
Mr. Lowe?
You are muted. You are muted. Justice Mhlantla, you are muted, and
Thank you. Just one last point. It relates to the judgment of the High Court. At para 20 of the judgment, that's volume 25, 2474, para 20 of the judgment. The court, now you've told us about the factual disputes that were there. Then the court, and also referencing us to the transcript of the hearing, the court says, I'm satisfied that without having regard to the evidence given at the section 152 inquiry, the applicants have, on the facts set out above, discharged the onus on them to establish their local standard as envisaged by section 12(1)A of the Insolvency Act. Which now facts are these if he disregarded the evidence that was led at the inquiry?
Well, we've dealt, Justice, we've dealt with the facts that he took into account in detail in our heads of argument, and we discounted each one of them. And we submit that those facts simply cannot be used to support the purported claim that His Lordship, the Acting Justice Sievers, found to exist. Because what it was contradictory versions put up in respect of things that Mr. Lowe had said. Now, we must in all respects, remember, we would submit that Mr. Lowe was by this time not a representative of the trust, could not make any binding admissions on behalf of the trust, and was saying things which by that time was a change to some extent as to what he'd said earlier. But what he'd set out to do was always clear. And we submit that Mr. Lowe did exactly what he set out to do in the circumstances. He tried not, he didn't intend to enter into any loan agreement with the HNP Trust at any stage, and he couldn't enter into a loan agreement with the HNP Trust on his own behalf at any stage. What he did was clear. He took money from his clients, and he tried to hide the origin of his clients' money when he effectively defrauded them of their funds by transferring the money through certain other accounts, such as Quintado's bank account, to Falaco, which he calls his company. So what he was trying to do is to favor himself by taking his client's money and transferring it eventually to Falaco. That is what he tried to do, and that's what he did. There was then, in order for him to hide the fact that he was in fact the person who had caused funds to be invested or transferred into Falaco, he caused this whole paper trail to be set up. And the evidence is there all over that he then asked Mr. Augustine to, for example, any amounts that came in from Mr. Lowe, which we journalized to a loan account of the HNP Trust in Falaco, for example. Well, we all know that's not what happened. We all know that's not what the truth is, but that's what the paper trail that Mr. Lowe created. The same Mr. Lowe created financial statements that show that there's a loan account of Falaco in Falaco in favor of the HNP Trust. We know that that's not so because that loan account was created in the fashion that we just pointed out. But furthermore, when one has regard, and we call it, I think somewhere in our written submissions, we call it we say that, sorry, I just want to get to the page. We call it the inferential leap, I think, in our heads or in our written submissions. What we see in these documents, and importantly in these documents, is Mr. Lowe did not even reflect in his own documents, which he tried to create, ever, that although he reflected Falaco as having there being a loan claim in favor of the HNP Trust against Falaco, he never reflected the same as between Mr. and Mrs. Lowe and the HNP Trust. The strange thing is that the same documents that the learned judge refers to at, I think it is at page 1080 of the record, if I'm not mistaken, and I will just briefly the documented, no, I'm talking about page 1108. It's Annexure CFB 6 to the affidavit, which is CFB is Mr. Bester's affidavit. So this is a document that was put before the court in the replying affidavit. The court relies on it. And the court says, well, it shows that there's a Falaco loan in favor, that there's a loan claim in favor of the HNP Trust against Falaco. And at page 1108, for example, this is the financial statements of the 28th of February 2016. Under leningsrekenings, loan accounts, it says Falaco 40 million, 5451373. But what one sees high up near the top of the page is what the position is between Mr. Lowe and Mrs. Lowe and the HNP Trust. And the position changed. 2015, Mr. Lowe was owed an amount of 48,000 rands. 2016, Mr. Lowe owes the trust an amount of 45,000 rands and some odds. So even the documentation created by Mr. Lowe, which he used to hide the fact that he had an interest in Falaco, that documentation never shows or doesn't show that Mr. Lowe considered himself to have a claim against the HNP Trust, a back-to-back claim. And that's what we say is the inferential leap that the court Akwo made and the respondents make, and they do in their founding papers and everywhere. They infer that there must have been a loan claim between Mr. Lowe and the HNP Trust, but it's certainly not borne out even by the documents that the court Akwo relied on. There's a further indication of what the position was. The nearest the applicant, the respondents ever come to establishing that there was a decision taken at any stage by the trustees as they should take decisions. And we refer to the trust deed because the trust deed is the origin of the powers and abilities of the trustees. And in the trust deed, you would have noticed there are provisions for all kinds of things to be done. But the one thing that there's no provision for, and which the authorities we say there should be provision for if you want to rely on it, is a general authorization. What it is a document, and the nearest they ever get to a document that shows that there was an authorization for Mr. Lowe to do anything was the 2015 resolution by the trustees, which refers to the entry into a suretyship. Now, the respondents say, "Oh, this shows that there was a resolution by the trustees that there would be a loan account between Falaco and the HNP Trust." It doesn't justify any such inference. If you look at page 1079, we say that document, of course, it's a standard Absa bank document, as one can see from the foot of the page on the right-hand side. That document merely authorizes Mr. Lowe to enter into a suretyship agreement. It then says in the form which has been presented to the meeting. Now, we don't know for a fact whether the form attached to page 1080 was in fact represented at the meeting or not. There's no evidence to that effect at all. But what is clear is that this resolution itself does not entitle Mr. Lowe to do anything such as to enter into a loan agreement between the HNP Trust and Falaco. In fact, on the next page where the actual suretyship is, it refers to a suretyship in respect of the debts of Falaco to the bank. And then at clause 4, it says that in addition to the suretyship and a security, there's a cession of rights in terms of loan accounts, which the trust may have in the future.
Mr. Van Heerden?
Yes.
At the risk of repeating a question raised by my sister, Justice Mhlanhla, I just want to know how exactly we are dealing with this matter insofar as the facts are concerned. In Makate, this court held that ordinarily we deal with legal questions on the basis of the decision taken by the High Court or Supreme Court of Appeal on facts. So we do not upset the factual findings made by those courts. And then we just grapple with the legal issues, whether constitutional or otherwise, based on those factual findings. I want to know how exactly, in the face of that principle, we are supposed to grapple with all of these factual findings.
I think, Justice, I have attempted to set out in what fashion the legal principles become important in this matter, and where the
No, I'm
legal
not now. Now I'm
dispute-
not at all engaging you on the legal issues. You have addressed that, and maybe you're still going to continue to do so. Now, my concern now relates to facts. I say a principle that was laid down in Makate, and probably Makate was reinforcing a principle that already existed. And that principle is, ordinarily, we deal with legal questions on the basis of factual findings made by the Supreme Court of Appeal or the High Court. We do not ordinarily upset those factual findings. So now what I'm saying is, in the face of that legal principle, on what basis are you saying we should reach and possibly even upset the factual findings made by the High Court in the face of the legal principle of fact?
Just as the submission, we submit that once your jurisdiction is engaged, in other words, once there is a legal dispute which you are entitled to entertain, then those are the circumstances where you cannot entertain a legal dispute in a vacuum. And where there are clear errors in the way that facts were presented to the court a quo, it would amount to an exercise that would be artificial to ignore the real facts when you are dealing with a matter already that falls within the jurisdiction of the court. And our submission, the artificiality of that would be patent if you, for example, bring a case to court on certain facts which are clearly wrong. On one issue, you engage the court's jurisdiction because there's a legal issue, and on other issues, there is a clear injustice on the facts because simply nothing justifies the court's factual findings. Under such circumstances in our submission, it would be artificial to exclude, and for this court, the highest court in the land, to close its eyes to the deficiencies in the judgments of the lower courts. And we would submit that as the court has now been vested with this jurisdiction to some extent, to the extent set out in the amendment to the Constitution, that it is now vested with the powers of the apex court. We submit that those powers must include, once one has reached the hurdle set out in the section, once one has reached that hurdle, after the hurdle is crossed, we submit the court should be at liberty to correct any other injustices that have occurred in the process, including where factual findings have no bearing on the facts that were adduced before the court. In this matter, we sit with factual findings that were made by an acting judge in a court a quo, which are in our submission clearly not based on any evidence. For this court, should it find that the jurisdiction is engaged, to simply ignore such findings and to say, well, we can do nothing about it in our submission, would not be fulfilling the functions and of this court. And we would submit there's nothing in the section engaging this court's jurisdiction that disables it from entertaining factual issues. What the section says, it's enabling, and we say the section enables you to have regard to the legal issues, but it doesn't disable you from having regard to the factual issues once you have engaged the legal issues. Those would be our submissions with regard to what you have put to me with regard to that, Justice.
Mr. Van Eerden, if I may, my brother presiding, yes, thank you. Just to I don't want to labor this point too much, but just to take it a little further as well, I would like to refer you to volume 25. That is the High Court's judgment in this matter and how this matter was dealt with by the High Court. Seems to me, if we have regard to the judgment of the High Court, this was dealt with as factual issues in the High Court. I understand that the applicant's two main grounds of appeal is that the estate failed to make out its cause of action in the founding papers, and also that Mr. Lowe wasn't authorized to conclude the loan agreements. Now, I'd like to deal with those two facts. If you look at page 3, paragraph 5 of the judgment, which is page 2470 of the record. From paragraphs 5 to 12 onwards, the judge, and whether it's a permanent judge or an acting judge, actually has no moment, Mr. Van Eden. The judge sets out the facts that are not in dispute. It's interesting to note in paragraph 12, says the above advices, recordals, and documents are not denied by the respondents, who content themselves by saying that they were false. So they were just, the respondent said that it didn't admit any of the documents, it just said they're false. The judge goes on to record, it must be emphasized that this allegation is now being made on behalf of a self-confessed fraudster and two trustees who at best acquiesced. If I can refer you to paragraph 17, Mr. Van Eden. It says, it is common cause that Lowe transferred the funds from his bank account to the account of Falaco, and that the corresponding credits were recorded against the loan of the account of the trust in the books of Falaco. Now, you would accept that the statements, the statements in the books of account that were attached to the founding papers reflected and recorded that loan.
Before you respond, Mr. Van Eden, your 45 minutes ended at 10:46. How much more? I know we've been engaging you and you are being engaged right now, but how much more time, based on what you believe you still want to make submissions on, how much more time do you require?
Justice, I'm not sure if I'll be able to answer these questions and then go back to the main submissions.
Just based on your on the submissions that you still want to make. For a moment, don't factor our questions. 15 minutes. All right. Please deal with my Sister Justice Throne's question then. Thank you. Justice Throne, the question you put to me, I'm not sure if we've got to the end of the question. I just want to make sure. Are you putting to me that you asked me that whether we admit that there are these documents?
Yes. My premise was the two issues that I referred to, that you say, Mr. Van Eden, are arguable points of law. The first, that the estate didn't make out a cause of action because the evidence didn't establish that Mr. Lowe had a claim against the trust. And the second, that Mr. Lowe wasn't authorized to conclude the loan agreements. Now, I want to take you to the judgment of the High Court to try to show or demonstrate to you that these were dealt with as factual issues by the High Court. And I'm not sure how they transcend into arguable points of law. The common cause or the facts are recorded, and I took you to where the facts are recorded. And then at paragraph 12, where the respondent denies those. What is set out, the respondent denies the records. and simply says that they are false. You also question the indebtedness to Falaco, but at that stage, Falaco's financial statements as at February 2016 was before the court and attached to the founding affidavit. Do you accept that?
Justice Tron, I do not accept that. I do not accept that the judge was right in what he was saying. I accept that these appear to be factual findings, except for the fact that these factual findings don't justify the conclusions of law that he tries to draw from those. I do not accept that those facts are correctly set out by the honorable judge in the court of quo. Those facts are in fact incorrect on the basis that we analyze in our written argument, but that they are statements of fact, except when he gets to his, perhaps one could call a conclusion, that we do not agree, where he says, for example, acquiescence, and where he says the two trustees, he says we're acting on behalf of a self-confessed fraudster, the trustees, etc. That is all incorrect. We don't admit, and we certainly take great issue with those statements. That they are statements of fact, we say they are not statements of fact only, they are also conclusions of law, which cannot be sustained either on the fact or on the law.
Now, I can accept that the trustees might be aggrieved by the use of the word acquiesced, but it doesn't change the facts that the High Court relied upon. And I was asking you about Falakio's financial statements. We accept, and they accepted that they had misrecorded what had occurred at the meeting of 13 December regarding the funds being channeled, regarding what Mr. Lowe may have said about the funds being channeled. But in the founding affidavit, Falakio's financial statements indicated that it owed the trust 44 million.
Yes, but that was, of course, incorrect, we say, but it is a factual finding. It's an incorrect factual finding to say that Falaco's financial statements were not questioned, first of all, and secondly, that Falaco's financial statements were correct. Falaco's financial statements were on the version adduced by Mr. Lowe, and which they should have given to the court in the first instance, not correct. Falaco should never have reflected the HNP Trust as a debtor in its as a creditor in its books of account, Mr. Lowe said, and also, as I pointed out earlier, these books of account of the HNP Trust, which he wrote up in 2016, showed that there could, in any event, never be an inference that there's then a loan account between the HNP Trust and Mr. Lowe.
Let's assume you are correct, Mr. Van Eden. Let's concern you are correct. Do you accept that Mrs. Lowe was indebted to the trust in the sum of 150,000?
That is the one claim that is a typical example of what we say the law does not allow. And I referred the court to the judgment that that holds that you have to make out your cause of action in your founding papers, and you cannot rely on a cause of action made out by your respondent, because the abuse that may arise from that is patent, we submit. Now, what happened in this matter with regard to the 150,000? The applicant made out, the applicants in the sequestration, which are the respondents in this court, made out no case whatsoever, we say, and we analyze it in detail. They make out no case, we say, of any indebtedness upfront in their founding papers. In the answering affidavits, there's then an analysis of the bank statements of the HNP Trust. And in the bank statements of the HNP Trust, right at the end, one finds that during the panic that must have set in when Mr. and Mrs. Lowe were sequestrated, Mrs. Lowe took 150,000 rands out of her own personal account and paid it into the account of the HNP Trust. No doubt, one would surmise, in order to try and have something to stay alive on while the sequestration was playing out. Now, that 150,000...
we can't surmise that. But my next question is, your client did not oppose the application of Mr. Berger to supplement his founding affidavit.
No.
So I'm not sure on what basis you can now object to that evidence having been placed before the court and the court relying on that evidence.
We are not, there's no question of objecting to the evidence in the supplementary affidavit. We say the evidence in the supplementary affidavit takes the matter no further, because the evidence in the supplementary affidavit is gainsaid by the very evidence which was suppressed in the founding affidavit, where Mr. Lowe said, but none of this is correct. Now they come and they say, well, we want to explain why there's false evidence in the founding affidavit. And when they come and explain that there's false evidence, they try to put up what made them think that what happened at the meeting was something else than what really happened. And in that process, they bring these other documents to light. But none of those documents can stand up the scrutiny of the situation that they find themselves in, because what they've done is they've put up two mutually destructive versions of the cause of action. The one version is...
Mr. Van Eeden, your client also withdrew the application to rescind the provisional sequestration order.
Yes. Yes. And the reason for that is set out in the papers. The reason for that was that the judge at the hearing was not convinced that the matter was sufficiently urgent and that a case had been made out for irreparable harm that would be suffered. And he asked, why is there any irreparable harm? We submitted that the irreparable harm is that the provisional trustees are carrying on with incurring costs on behalf of the trust, and in terms of the order that they obtained for their powers to be increased, and they then open court tended not to incur any further costs until the return day, and on that basis we were obliged to withdraw the application because the court was clearly not inclined to hear the matter urgently when that undertaking was given, namely that there wouldn't be irreparable harm under the circumstances. That was what happened, and that's why that application was withdrawn.
Yes, but is paragraph 18 of the judgment not also relevant, Mr. Van Eeden? It says, the written recording of such resolutions authorizing the loan of the funds from the insolvent of state would have frustrated the whole purpose of using the trust as a conduit for funds, which was to hide the illicit source of funds and to move the stolen assets.
It's not clear what the learned acting justice wanted to do here, but what he's saying is that if there was a written recordal, then of course, it would have appeared to everybody in the outside world that actually the money was coming from Mr. Lowe. The difficulty is, of course, that nobody, or other than the other trustees, would know about an internal resolution of the trust, which enables Mr. Lowe to do and enter into loan agreements. Nobody else would know about it. Why would that be a reason not to take it? The reason why it didn't make a recordal is because there was no resolution. And in any event, the terms of the trustee don't allow you to make a decision without complying with the provisions of the trustee. To reject the version of Mrs. Lowe to the effect that she didn't know about these loans is entirely unjustified on the papers before the court quo or the papers that are before this court in our submission.
If I can just conclude on this aspect, Mr. Van Eeden, and I'd ask you to have regard to the judgment again. At paragraph 12 onwards, the High Court judge then deals with the dispute. The judge deals with the respondent's argument that the application should be dismissed on the basis of the incorrect information that was initially placed before the court regarding the meeting of 13 December 2018. The judge accepts that that was correct. Paragraph 14 says, after the granting of the provisional order, the applicant sought and were granted leave to file supplementary founding affidavits, to which the respondent filed supplementary answering affidavits. The matter has thus been fully ventilated. Paragraphs 16, 17, 18, and 19. The judge then deals with these facts, and the judge concludes in paragraph 20 that the applicants have established a claim against the trust. Paragraph 21, the judge says, once the claim is accepted, it is clear that the trust is hopelessly insolvent. What I've tried to demonstrate, Mr. Van Eerden, that the disputes and the issues before the High Court was factual. And the High Court made certain conclusions and findings based on the facts that were before it.
Justice Troon, I understand that if the purpose of the discussion is to say that the findings were all factual, we submit that of course, there were largely factual findings in the judgment. And those factual findings, however, were used to draw conclusions that were legal conclusions. We say that even if those factual conclusions are correct, with regard, for example, to acquiescence, and so far as there were any factual conclusions made, those factual conclusions do not justify the legal conclusion that the court came to, namely that the trust acted. The court did not make a finding rejecting Mrs. Lowe's evidence. The court did not make a finding rejecting the evidence of Mr. Cronje even. So what the court did is to say, well, they allowed Mr. Cronje, Mr. Lowe, to do these things. To allow somebody to conduct the affairs of the trust is not enough, we say in law, to bind the trust when afterwards those actions are questioned. If the other trustees are not aware and the other trustees do not agree and do not make a decision, a conscious decision, to authorize one of them to conduct particular transactions, then there is no authority, we say. And therefore, on that score, we say, even if the factual finding in relation to acquiescence was correct, that's not good enough. But in any event, we say that the legal issue that is engaged in this matter is also closely linked to the factual dispute with regard to what cause of action was made out in the founding papers. The cause of action that was made out in the founding papers, we say, or alleged in the founding papers, had simply no basis in fact, firstly, and that is clear if one reads the analysis of the the judgment in the court a quo that is in our written submissions. But also the fact that they were allowed by the court a quo to adduce evidence with regard to, not to adduce evidence, but that he took into account evidence which effectively tried to set out a new cause of action when the original cause of action was not backed up by the evidence in the founding affidavit, is also a legal issue, we submit. I just want to perhaps, I've taken the court to the documentation which we saved shows clearly, and I just want to perhaps refer the court to the arguments where we set out in our written submissions to the court, where we deal with each and every one of the issues on the facts that the court a quo erred in relation to its findings. We set those out in our heads, and we say that those are dealt with fully in paragraphs, I think paragraph 20, paragraph 32. From the paragraph 32, we deal with the court's principal grounds for its findings, and we say in respect of each of them why they're incorrect and why we contend they cannot be sustained, particularly in the light of Mr. Lowe's contradictory evidence, which they relied on and which they had to concede was given at the meeting of the 16th of December. With regard to the issues relating to the trust, we deal with those. We deal with the cause of action issues at D, and I just want to briefly say that Kleinhans's case does not justify the point made in paragraph 85 of the heads of argument on behalf of the respondent. The Kleinhans's case was in fact a matter which was based on the old adage that only certain types of claims can qualify as liquidated claims, and the two competing contentions that were before the court, one can see.
Mr. Van Heerden, the 15 minutes ended at 11:04. How much more time do you want? And that will be the last bit.
Justice, I just want to refer to this last issue. Kleinhans's case is a case where the parties, it's number 11 of the list of authorities of the respondent, and in Kleinhans's case, the cause of action was theft, and on the papers it was not properly disputed by the respondent that he'd stolen 150,000 rands. The court said Mr. Fleming, who appeared for the appellant, who was the thief, alleged that you couldn't sequestrate on that cause of action because he says that a sequestration order has serious consequences for respondent and ought therefore only be granted when liability is already determined. Certainty as to existence of the debt has been retained as an element of the phrase liquid claim in sequestration matters. And he says, thus a sequestration order can only be granted on a certain cause of action, for instance, a judgment of court on admitted debt. What he effectively contended, and this is at page 744, he effectively contended that you cannot grant a provisional order of sequestration on the basis of theft. And his opponent in the matter said, no, that's not so, and that all you needed was that the cause of action should be proved and that it should be liquidated, and one would find those submissions at the foot of page 746, where Mr. Beck, I think, says it must be determined or easily determinable, and naturally the validity of the cause of action will have to be established. The court then looked at the issue, and although it appears perhaps on a very superficial reading as if the court said you do not have to make out the ground, the court accepted that the cause of action was theft. And the court said, well, if you make out your case for 150,000 rand, that's a liquidated sum that's been stolen, it does not matter that it's for theft or some other cause of action. The point is that there is a cause of action, of course, but also that it's liquidated. And it says that that is the effect of the judgment, not as the respondents contend repeatedly, and they did in the quota quo, that one doesn't have to specify your cause of action. That is clearly not in accordance with the provisions of Section 9 of the Act, which provides expressly that the amount caused the nation should be set up.
Mr. Van Heerden, let's manage this. How much more time? I'm not giving you more than 5. How much more?
Justice, I'm going to conclude my submissions. I stand by what we say in our written submissions, And we submit that there is a legal issue that engages the jurisdiction of this court, and that there are extensive errors as we set out in detail in our written submissions, and that the application should be granted and that the appeal should succeed with costs.
Thank you very much. Thank you very much, Mr. Van Heerden.
That's the court.
Mr. Van der Merwe?
As it pleases the court.
Perhaps it's best to take the tea break now and resume at 11:25.
As the court pleases.
As the court pleases.
Court adjourned.
You're on mute, madam.
Please, court will adjourn until 11:25. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with the video and sound when the hearing recommences at 11:25. Should you exit, you may use the same link to rejoin the hearing.
Thank you. Colleagues? Thank you. Yes, Mr. Van der Merwe?
As a
Justices
plea,
of the Constitutional Court, all counsels are online.
Thank you. I'm sorry, Ms. Registrar Clerk. Yes, Mr. Van der Merwe.
thank you, Justice. Justice, the respondents, the insolvency trustees, will raise the following arguments. Firstly, the applicants in the HMP Trust matter have not engaged this court's jurisdiction. It is clear that they do not rely on a constitutional issue. We say that they do not raise any point of law in their application. And we also say that they do not even allege that it is in the interests of justice for this court to deal with the application. But in any event, we say that there are no interest of justice grounds which would engage this court's jurisdiction. The second issue, which we will address very, very briefly, is as to the merits of the application itself. We submit that clearly a case had been made out on the facts, both with regard to the locus standi issue and with regard to the authority issues, which are the two factual bases upon which the applicants seek leave to appeal. We will not make further submissions. We have raised in our heads of argument the question of a referral back for the receipt of evidence and or oral evidence. We will not make any further submissions on that. Our submissions are contained in our heads of argument. They're made in the alternative only. And lastly, we will make very brief submissions on the issue which this court in its initial directive requested us to address, and that is the effect of the Quintado case, of the Quintado judgment by His Lordship, Mr. Justice Binns Ward, on the HMP Trust application. If I can then start with the jurisdiction issue. The applicants raise two primary grounds of appeal. Those are, we say, purely of factual in nature, and that is that the insolvency trustees have failed to demonstrate on the evidence that the insolvent estate had a claim against the HMP Trust, also referred to as the locus standi issue, and secondly, failed to either demonstrate or allege that Lowe was authorized by his co-trustees to advance a loan to the HMP Trust. Applicants contend that the grounds of appeal give rise to 3 points of law, which they describe in paragraph 10 of their application for leave to appeal, which is at volume 26, pages 2510 to 2512. We submit that none of the grounds as formulated in paragraph 10 raise any arguable points of law. In essence, we say that the complaint that the applicants raise on the first ground amounts to a contention that the respondent's cause of action was not established on the facts or the evidence, and that the court was incorrect in finding that it was so established. They also appear to contend that the court a quo misdirected itself either by finding a cause of action in the absence of evidence or by failing due regard to the lack of evidence. As regards the second ground, that is the authority point, they contend that the evidence apparently subverts established legal principle. They do not complain about the legal principle. They're simply saying that the evidence does not justify the finding of the court a quo in that regard. We submit that this court in McCarthy, and we cite a portion of the judgment in paragraph 23 of our heads of argument, made it quite clear that this court must not be saddled with the responsibility of resolving factual disputes where disputes of that kind have been determined by lower courts. Ordinarily, an apex court declares the law that must be followed and applied by other courts. Factual disputes must be determined by the lower courts. And when cases come to the apex court on appeal, they should be adjudicated on the facts as found by the lower courts. Furthermore, we submit that the applicants fail to allege in their application that the interests of justice require this court to interfere with the findings by the Quintado quo. The applicants do not rely on an allegation that the Quintado quo applied any incorrect legal principle to the case. The allegation is that the facts were incorrectly applied. At best, the applicants contend in their application that this court should reiterate an established legal principle that sequestration proceedings should not be used in an abusive manner. It is an established legal principle. There is no question of law that needs to be addressed on that issue. With reference to the matter of the General Counsel of the Bar versus Jiba, where this court held that the court's jurisdiction was not engaged, this court held in paragraphs 58 and 59 of that decision, firstly, that a decision that is based on wrong facts does not amount to an arguable point of law. Secondly, that the wrong application of an established legal test does not constitute an arguable point of law. We submit that the principles applied in Jiba apply equally to this application. We therefore, in conclusion, on this point, make the submission that none of the three grounds raised by the applicants raise any arguable points of law. The applicants have also suggested that as far as the merits are concerned, the insolvency trustees failed to prove locus standi, and we submit that they've secondly suggested that the applicants sought to make out a case in their founding papers, that they abandoned that case in later affidavits, and that they sought to make out new causes of action. We submit that that is not correct. The record does not reflect that. We submit that in fact, the court's findings were correct as far as the references in the Quintado's judgment is concerned to the factual findings relating to establishing locus standi. And may I just at this point point out that not only was Falaco's annual financial statements for 2015 and 2016 before this court, before the Quintado quo, but also Falaco's annual financial statements for 2013 and 2014. They do appear in different parts of the record, between volumes 1, volumes 5, in 2 cases, and volume 10. The significance of the first 2 annual financial statements of Falaco is that Mr. Cronje, who's the deponent of the affidavits for the HMP Trust, in fact audited those annual financial statements. He signed them off as auditor. He later attempts to distance himself from the audits by saying, well, he missed those facts. It's incomprehensible that a qualified auditor can say that he signed off an audit of an annual financial statement, but that he missed a loan account recorded in the amounts of varying amounts, because the loan account obviously developed in quantification between 2013 and 2016. But in all those financial statements, the loan accounts were substantial, several millions of rands.
Mr. van der Merwe, can I just ask, do you accept that the Plascon-Evans rule applied on the return day?
To disputes of fact, they would, yes, yes, Justice.
If one looks at the High Court's judgment in volume 25, there's what I would think is a very cursory summary of certain matter, and then paragraph 20 at page 2474, the conclusion, I am satisfied without having regard to the section 152 evidence that the applicants have discharged the onus. Is there anywhere in this judgment that one sees an appreciation by the High Court judge that the Plascon-Evans rule applied?
Justice, the High Court judge did not refer directly to the Plascon-Evans rule, but it is, I submit, trust that judgments are not all embracing, and that even though the rule is not referred to, it must follow from the court's judgment that it was satisfied that the locus standi had been established on the evidence. And I submit further that even though the judgment deals fairly in fairly brief terms with the facts, and in fact there were more facts, those factual findings are not incorrect. They are justified if one has regard to the evidence.
I can understand that one might take it for granted that a High Court judge would, in final order proceedings, determine the case with reference to the respondent's facts without explicitly mentioning the Plascon-Evans rule, because that is the standard or default position. But if a judge is going to say that allegations of fact made on behalf of the respondents are so far-fetched as to be untenable and can be rejected on the papers, does that not require at least some reasoning? And if so, does one find any such reasoning in this judgment?
Justice Rogers, it is clear from the judgment that the judge in the court of first instance did not deal in depth with the Plascon-Evans rule. And
no, but did he deal at all with it? Is there any reasoning to explain why you say, for example, well, it's incomprehensible that Cronje could not have noticed the loan account indebtedness to the trust, yes, as recorded in the financial statements? That's one of a myriad of factual disputes that there were in this case, which included that Mr. Cronje and Mrs. Lowe had no knowledge at all of the manipulations in which Mr. Lowe was engaging. It may remain a question whether it engages this court if the High Court failed to do what it should have done. But I find very troubling that there's absolutely no analysis of that, no explanation as to why the evidence adduced by the respondents' witnesses has been discounted, it appears to me, on every material issue without explanation.
Justice, I can only add that one of the major questions that was relied on by the trustees of the HNP Trust at the initial hearing was this question of the incorrect summary of the evidence given at the meeting of 13 December by Mr. Lowe. And the court did address that issue in its summary of the evidence and in its judgment directly. It seemed to have played a major part in the HNP Trust's approach to the matter.
Well, that was really tied up with whether there was whether the provisional order should ever have been granted, but it doesn't really bear on the disputes of fact which determined whether or not there was locus standi and whether or not the trust was bound by the things which the applicants for sequestration were alleging.
The finding of the court of Quo doesn't deal directly with those disputes, Justice, and I can only submit that it follows from the court's findings that it was satisfied that that no real disputes were raised on the papers in relation to those two issues. In other words, that they were factually approved by the applicants.
Yes, thank you.
Mr. van der Merwe, I didn't get a chance to engage Mr. van Eden on this earlier, but I want to deal with your citation of Kleinhans versus van der Westhuizen, which you cite under the first ground, which is the question of the cause of action. Now, the passage that you refer to there is in reliance on the submission that once the monetary value of the claim is apparent, the liquid nature of the claim is established and it's unaffected by the question as to whether or not the cause of action as distinct from the monetary value is determined or easily determinable. Like he said, that case concerned the theft of monies. The ratio decidendi in that case, if you meant that was what was said at 746G, doesn't strike me as saying that what you are saying. It doesn't seem to me that Kleinhans versus van der Westhuizen holds that there's a different test to be applied, because that passage that you cited, 746G, must surely be seen in the context of the case for what it was, a theft of monies case. Not so?
Justice, yes. And if I may add, my submission would be that the case's ratio does deal with the question of liquidity rather than whether it is necessary at all to establish a cause of action. I think the submission was that as long as the court is satisfied as to the liquidity of the claim, it is not necessary to make a firm finding about the particular or the precise cause of action. However, our submission is on the facts that we have contended for a loan. All the evidence points to a loan, and therefore our reliance perhaps on Kleinhans it misses the point. Our point is that
sorry to interrupt you, but that's exactly. It almost sounds if you cite Kleinhans, you're arguing against yourself, because yes, frankly, I also have problems with jurisdiction, and I see this purely as a factual dispute, and it's exactly why I raised Kleinhans. It seems to me to be arguing against yourself. And then secondly, while I have time, the second aspect which you raise is the question of lack of authority. Well, let me first go back to the first one. It seems to me that in recent times, the last 10, 20, 30 years, there are very few cases reported, even in the High Court, about cause of action as it appears in the Insolvency Act for self-evident reasons. It's become so well established. But secondly, on the second ground, that's lack of authority. It seems to me there too, the law is well settled. If you think about cases like Land Agricultural Bank versus Parker and so on, the law is well settled. And what remains then, and as I say, I didn't get a chance to put this to Mr. van Eden, it seems to me the law is well settled, and we're disputing here about who said what and what was probable in the circumstances, what should have been rejected, and now on the facts. Not so?
Justice, I would entirely, with respect, agree. And I just want to also point, the law firstly is well settled, especially in the Vrystaat Millies and the Parker Land Bank decisions. But Mr. Justice Harms, who gave an additional judgment in the Vrystaat Millies case, made the point quite forcefully in paragraph 23 that the question of authority is always a question of fact. It does not involve a question of law, and therefore the issue turns purely on a consideration of the facts.
Yeah.
And
yes, thank you.
Thank you. I was just dealing very briefly with the factual basis for the claims, and I, at the risk of arguing against myself, I do not want to take the court through each and every fact, because we submit that there are that the evidence quite clearly established in a number of.
We've seen, Mr. van der Merwe, we've seen what you highlight in your written. Yes. In fact, you don't highlight what you deal with extensively in your written submissions. We've seen that. Take it that we have taken note of it, and we will take it into consideration. Is there anything specific that you want to highlight, perhaps?
Perhaps I can just something that
emphasize
perhaps something that seems to have been missed, that the resolution which was included in the papers in this case appears not to have been the only resolution. The annual financial statements also show that there was a 2011 resolution relating to a further session to Absa Bank, and that there is a plethora of facts which point to the, and this is on the authority issue, to the trustees in fact knowing about the existence of the loan, quite contrary to the assertion that they did not. As to the 150,000 Rand claim, which was alluded to briefly in arguments, we also submit that that evidence is properly before the court. It was placed before the court, and that evidence is found in the schedule of payments which were made to the HMP Trust, which was in fact annexed to Mr. Cronje's affidavit. It is to be found at volume 3, page 294, where that payment is clearly recorded. The fact that Mr. Cronje later admits it adds a grist to our mill, but it's a clearly established fact which this court can, or which the court could take into account. But briefly on the authority issue, I've referred to the Vrystaat Millie's principle. We submit that this is still a factual question, so I'm not going to stand still with it, but general authorization we submit is a principle which is applied in our law. The judgment of Mr. Justice Cameron in the Land Bank case, if I can just ask the justices to bear with me for a second. In paragraph 37.2, Mr. Justice Cameron found that the inference may in appropriate cases be drawn, although the inference wasn't drawn in that case, that a trustee who concluded the allegedly unauthorized transaction was in fact authorized to conduct the business in question as the agent, as the other trustees. And we make the other point, he makes the point that in Nivout Vrystaat Millies, that matter was referred back for the question of authorization. But that in that case, both parties had relied on an incorrect interpretation of the trust deed in that case. So we submit that general authorization is a principle in our law that's established, and we submit that it applies to the facts of this case. The applicants rely on the question on DDAT's case in their heads of argument. We submit that DDAT's case does not find application in this case. It's distinguishable on the facts. DDAT concerned a religious trust where one of the trustees who had suffered a stroke attempted by delegating authority to an outside party who was not a trustee. And we submit that the facts in that case are distinguishable, and principle established in DDAT does not apply to the facts of the case. Justice, I wish to conclude my submissions by making a brief submission on the issue that we were asked by this court to address at the outset, and that is, does the Quintado judgment of His Lordship, Mr. Justice Binsward, have an effect on the outcome of this application? We submit that it does not. We submit that it does not. In fact, regardless of whether this court may or may not interfere with the court Arquo's judgment in Quintado, we submit that this application stands on its own legs. There was obviously an interrelatedness in the sense that the parties were closely related and the facts were very closely related to each other, and there's a certain overlap of facts, but we submit that what Mr. Justice Binsward found does not affect this application, and what we submit would be the appropriate course in this application. We accordingly submit that the appropriate order in this case would be to dismiss the application for leave to appeal with costs. Unless there are any particular aspects which justices wish to hear me on, those are our submissions.
Thank you, Mr. Van der Merwe. Mr. Van Eerden?
Thank you, Justice. Just want to reiterate 2 points. My learned friend says we have not pleaded or alleged that it's in the interest of justice. We submit that that is a conclusion to be drawn by the court, and the mere fact that one says in your affidavit that it's in the interest of justice adds nothing to the matter of consideration of whether it is in the interest of justice to grant leave. We say that the about 150,000 rands claim, I think the submissions have been made with regard to that, and that injustice is painted, but we add that the 150,000 rand claim, if that was made of the trust before provisional sequestration, the trust would have been easily be able to pay it because it had more than that in its bank account at the time. The references are in our heads and in the application. The 150,000 rands was not a claim relied on by the applicants and can never be the basis for locus standi under these circumstances. The trustees, after provisional sequestration, could never pay the amount legally or validly anyway, because they're not in control of the trust. The provisional trustees in insolvency are in control of the trust. Then, with regard to the question of Plasko and Evans, we submit that the court's failure to refer to the rule or consider the rule in its judgment would indeed amount to a legal issue. But under the circumstance of this matter, it is clear that the failure of the court to apply the rule led it to the factual mistakes which we say were made in the judgment of the court.
But I'm sure you did observe, Mr. Van Eerden, that my brother Justice Rogers, who raised this, did say that, but that of course is subject to whether or not this court's jurisdiction is engaged.
Yes, of course, and that is so. And with the court would have to find that it has jurisdiction on the basis that that is a legal issue under circumstances such as these. Without anything further, those are our submissions, and we submit that the application should be granted and the appeal should be granted as prayed.
Thank you very much.
Sorry, Mr. Van Eerden, would you care to, sorry, my brother, would you care to respond to what I put to Mr. Van der Merwe? If I also read Kleinhans versus Van der Westhuizen in the ratio to not to say what Mr. Van der Merwe claims it says in his heads at paragraph 85. Now, if that is so, what is left? If Kleinhans versus Van der Westhuizen is distinguishable here, what is left? Is it not then that on both these aspects, the law is pretty much settled on the first one, cause of action? Again, I say there's a dearth of authority in recent times concerning that question, simply because the law is settled. And secondly, on lack of authority, I would have thought that cases like Land and Agriculture Bank versus Parker has pretty much settled the law on that. So what's left is the facts, isn't
it? Justice, in our submission, it's not only the facts that are left when one considers those judgments, because what the legal issue that remains intact, we say, is that if the court makes a finding on the facts, which in this case it did, we say it's the wrong facts, but in any event, even if it was correct on the facts with regard to the question of authorization, and even if it was correct on the facts with regard to the issue, well, only on the issue of authorization, actually, then the law which it applied, insofar as it applied any law, was not the correct law to apply, and that the court's insistence on applying acquiescence as the only basis upon which it held a trust liable for the actions of a rogue trustee was unfounded. And in our law, my learned friend says, well, there is general authority. There's no evidence of general authority, but in any event, we submit that general authority cannot occur where the terms of the trustee doesn't make provision for it impliedly or expressly, and this trustee certainly doesn't do so. And those are submissions on that in that regard.
Thank you.
Thank you, Mr. Van Heerden. Mr. van der Merwe? Quintado.
Thank you, Justices. In Quintado, we submit that firstly, a constitutional issue is raised, and that issue relates to the test for attribution in our law as applied to civil cases. The court au quo applied the Canadian dredge test strictly to the facts of that case, and whether rightly or wrongly, we submit firstly that an application of the Canadian dredge case is inappropriate, and that the law in this case should be developed, especially the common law, in terms of the provisions of section 39(2) of the Constitution. We say so because we submit that a more flexible approach would be in line with policy considerations that arise in the whole issue of attribution of a director's conduct to a company, especially in the context of facts such as these, where misappropriation of funds, fraudulent conduct by company directors and the like is endemic in this country at the moment. We say that it is also in the interest of justice that this court decide this issue, because if the judgment of the court au quo is permitted to stand, it would be manifestly give rise to unfair results. Firstly, there is the question of whether the application of the Canadian dredge case is appropriate in our law, given that our criminal law does provide for attribution in terms of section 332 of the Criminal Procedure Act. In effect, if Canadian dredge is applied to our civil law, a more stringent test is applied to our civil law cases than would apply in criminal law cases, and we submit that that is anomalous because criminal law carries a heavier burden of proof. Secondly, as to the further anomalous results, we will submit that the effect of the judgment of Mr. Justice Binns Ward in the court au quo is that defrauded victims of Mr. Lowe's fraudulent scheme and investors are going to be left effectively without a remedy. They will need to try and establish where money ends up down the line that they invested. They would not be able to knock on the door of the person to whom they paid the money, or find solace in a cause of action in that way. They would be left, in this case, to chase Falaco for its claims. And that gives rise to all sorts of difficulties. How would the investors know where to start finding the money? And even if they did establish that the money ended up at Falaco, what would their cause of action be against Falaco? Would they really have one? Falaco would be the first company to turn around and say, but there is no connection between us, and you don't have, or you haven't established a cause of action between yourself and the company. We submit that that result in itself would also be unjust, manifestly unjust and unfair, unless the issue of attribution is addressed and addressed through a more flexible approach, which would give rise to claims being lying where they arise when monies are paid into bank accounts and passed on to further entities, as in this case. That, in summary, will be our submissions. If I can then turn to, and perhaps I might just say that the application had also been filed late. We have applied for condonation. We have made certain submissions in our heads of argument, and we obviously apply to this court for condonation. We submit that the application was not filed. The period of delay was not many days, it was 8 days, and the reasons were explained in the application. We therefore will request the court to condone the late filing of the application for leave to appeal. The testing Canadian dredge was applied by the court of first instance in the judgment in this case, and the court then applying that test held that the conduct of Mr. Lowe cannot be attributed to Quintado because, and on all three legs, the court held that the test had not been satisfied. As pointed out in the cases in which we cite in our heads of argument, the Canadian cases, firstly, the Deloitte and Touche matter, 2017 matter, where the Supreme Court of Canada firstly held that a court may decline to apply what was referred to in Canadian dredge as the corporate identification doctrine if it would be in the public interest to do so. In 2018, the Ontario Court of Appeal in DBDC Spadina Limited went further and held that the test could be applied in a less demanding fashion. A more flexible approach, in other words, was advocated for the application of the Canadian dredge case. We do cite from that case a relevant passage at page 10 on paragraph 25 of our heads of argument. In that case, it was also, the point was made that that particular civil case involved complex multi-real estate transaction investment fraud. And the case therefore while it involved civil claims, it dealt with the background of a complex investment fraud, as does the present case. In that case, there was a minority judgment where Van Rensburg, the acting Judge Van Rensburg held in that case that he disagreed and that the Canadian dredge case should be strictly applied. And as we point out, the Supreme Court of Canada on appeal simply followed the minority judgment and overruled the majority judgment in that case. So the state of law in Canada does not directly support our contention. However, we submit that questions of public policy do arise, and given the nature of the issues that arise in this case, our law should apply a more flexible approach to an application of the Canadian dredge case to attribution of directors of companies to the actions of their directors. We developed the argument that in the matter of K versus Minister of Safety and Security, which this court decided in 2005, it held that the principles of vicarious liability were regarded through the prism of section 39(2) of the Constitution, and the court went on to hold that principles of vicarious liability were imbued with social policy and normative content, and the application therefore had to be developed to accord more fully with the spirit, purpose, and objects of our Constitution. And we submit a similar application commends itself in this case and ought to be applied to the appropriate test for attribution to be applied in our law. We submit analogous to the issue of vicarious liability, that the question of the policy considerations behind the question of the attribution test are similar to those underlying vicarious liability. Do you understand that the tests are different, but they are similar parts of policy?
The 10 minutes is up, Mr. Van der Merwe.
Thank you, Justice.
Thank you. You may continue.
Thank you. If I may just stand still for a moment with Section 332 of the Criminal Procedure Act, the formulation of what is essentially the company's responsibility for the actions of its directors in Section 332(1) of the Companies Act is quite different to an application of the attribution test, but it appears that the formulation, at the very least, does not require compliance with the third step or test in Canadian dredge, being that the action taken by the directing mind of the company was by design or result partly for the benefit of the company. Therefore, appears in our submission that Section 332 of the Criminal Procedure Act requires less stringent, strict test for companies to be held criminally liable for the actions of their directors.
Mr. van der Merwe, let's look at the judgment of the High Court. The High Court, when I read the judgment, appears to have considered this test. And if you look at the paragraphs up to end of para, in fact, at para 25, it also refers to the fact that the test has been considered by the SCA. And my understanding of the judgment is that it says at the end that a pragmatic approach should be, is appropriate. Now, where it says that, and your plea is that a flexible approach should be a flexible approach will be able to be in line with the public policy issues and Section 39. What is the difference between when one says a pragmatic approach must be adopted and what you are seeking? Is there a difference between the two, pragmatic and flexible approach?
Justice, it's not clear, I submit, what Mr. Justice Binswoord had in mind when he spoke to the word pragmatic approach. He was
is he not saying that? Is he not actually saying that one should be flexible and consider a case on a case-by-case basis? And that's the same thing that was said by the SCA in the CNA judgment. Is it CNA? Yes.
Yes. Justice, my submission is that Mr. Justice Binswoord, while acknowledging the dicta of North's LJ in the El Adju case, which he was citing for that proposition, when it came to the application of the actual test, he did not apply a flexible approach to the test. He, in fact, looked strictly at the three requisites and made a finding as to whether the facts in each case either fulfilled the requirements or did not fulfill the requirements. And I submit that when the approach of the quota quo is considered, it is clear that a flexible approach was not adopted.
Now, in the flexible approach that you are proposing, what else should the court take into account when determining a case of this nature?
We submit that what the court or the approach the court should follow is firstly to look at whether the outcome in a particular case will be unfair or unjust, and if, for example, and this is a prime example we submit where the outcome will be unjust, because taking an inflexible approach simply means that firstly, the perpetrator or the family of the perpetrator of the frauds will manage to get away with essentially keeping the proceeds of or the assets away from the creditors, the ultimate creditors of the company. And our submission will be that the actual outcome will be unfair in this case. It would be very difficult for creditors to follow and to in fact be able to follow where their money went to and what the and what their causes of action would be in the circumstances of a case such as this. A flexible approach in line with public policy considerations aligned to the Constitution would look at that situation, look at what the relevant facts are, and in these situations would come to the assistance of the creditors by holding the company liable for the director's conduct. And this is not a case, in this case, two directors of Quintado are Mr. Lowe and Mr. Kellerman. And we know that Mr. Kellerman has attempted to conclude a contract in terms of which he's hived off, taken possession of all the assets of the HNP Trust in this case, which are the only assets available, and in that way has attempted to keep the creditors away from being able to recover what is due to them. So the flexible approach would require each of those three elements to be considered flexibly, and to look at the justice of the outcome, and to look at precisely when a company should be held to be liable for the conduct of its directors.
Do you look at the benefit, whether the company received any benefit from the conduct of the director, whether directly or indirectly? Would that be one of the considerations? How far should one go in determining that, if one should consider it?
Justice, yes, I think a flexible approach to that leg, for example, would be would inter alia be the mere fact that the company did not benefit completely should not in itself be a bar to holding the company liable. The Canadian dredge test, the third leg of the Canadian dredge test requires finding that the company was either by design or result, or the action taken by the director was either by design or result, partly for the benefit of the company. If that was so, then the attribution test is satisfied. In other words, the company will be liable. But if there is no evidence that the company has benefited, then it will not. Now, in this case, it so happens that we make out a case on the facts, but we know that factual inquiries do not on their own engage this court's jurisdiction. But in this case, we make out in our heads of arguments, and we've made references to the record, that the company has in fact partly benefited, because we know that the farming venture, which was operated through the banking account of the company, also earned an income, and so monies paid into the bank account were used to pay for farming expenses in the account, and that those were legitimate uses from which the company in fact benefited. In fact, there's that evidence is also contained in the report by the auditor, Mr. Ferreira, who said that the company benefited in the amount of at least 6.1 million rands of as far as payment of legitimate expenses were concerned. But to get back to your question, Justice, we submit that a more flexible approach would bear all those factors in mind, and the test we submit should be flexible enough to be applied to the facts of the case to achieve a just and equitable result.
Thank you.
Sorry, Justice Madlanga.
Thank you, Justice Rogers. With you as well, I have concerns about jurisdiction, Mr. van der Merwe. You peg your constitutional jurisdiction on section 39(2) of the Constitution, and section 39.2 requires or enjoins courts when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. So I read that to say there must be some underlying basis that informs the interpretation, the underlying basis founded on or undergirded by some rights in the Bill of Rights. Maybe I missed it both in your written submissions and in your argument before my sister Justice Mhlanhla engaged you. But I do not remember what rights in the Bill of Rights you rely on for purposes of saying to us, let us invoke section 39.2. You referred to K versus Minister of Safety and Security. That case, like Camichel, at issue there was the right to dignity and also the right to freedom and security of the person. If you look at paragraph 18 of the K judgment, you will see that in K itself, the point I've just referred to is made. And then in that same paragraph, Camichel is quoted, and that same point is made in the quotation from Camichel. Now, just explain to me how exactly in your case you are referring to farms and bank accounts of farms and the income and so on. I just don't see how rights in the Bill of Rights are implicated for section 39.2 to come into the equation.
Justice, we're looking at it from the perspective because the insolvency trustees are representing the interests of creditors. And we're looking at it from the perspective of those creditors, and we're submitting that their rights are affected. Arguably, there's the right of access to courts and under section 34 of the Constitution, and there may be other rights if the effect of the findings of the court are such that it effectively prevents the creditors from recovering through the insolvency practitioners what would be rightfully their claims through an incorrect application of the attribution test, then we submit it does affect their rights. It might very well also, and I do acknowledge that this wasn't squarely raised on our papers, but it might affect their rights to dignity, but we say access to courts.
Sounds like a very long shot.
we submit it. Sorry, Justice, yes.
Yes, no, continue, Mr. Panamero.
No, those are my submissions in response to your question.
Thank you.
Mr. van der Merwe, am I right that the injustice you perceive in this case is that a large body of investors will have to go searching for the money, whether with Falaco or elsewhere?
Yes, Justice.
That's not a consequence of anything to do with attribution of knowledge. That's a consequence of a finding that the money that found its way to Falaco was the money of the investors and not of Mr. Lowe. The judge was wrong on that point. The trustees of the insolvent estate could still pursue the claim, but they would pursue it against Falaco, not against Quintado. Is that not correct?
Justice, if our submissions on Duma and versus Whitehead are correct, and we submit that they should be, then yes, technically the claims must lie in the hands of the insolvency trustees.
All right. I just wanted to clarify that the injustice, and supporting a flexible approach on attribution of knowledge, in fact, is not the answer to the injustice you see. The injustice you see is fragmenting the claims of the creditors and requiring them to take individual action. But that has nothing to do with whether the ultimate debtor is Quintado or Falaco.
Justice, yes, no, I do take that point, but there is a second leg to the injustice, and that is that it would be equally difficult for insolvency practitioners who come to the insolvency. They have no knowledge of the affairs of the trust or the company, and they have to determine how to go about protecting the rights of the creditors. And it would be very difficult for them to do so if they were not, if they were precluded from applying the attribution test in this kind of matter, where monies have been paid into a bank account and then unpaid further.
Well, am I right that the trustees aren't in ignorance of what happened? They use their powers of investigation, which are quite extensive and coercive, to find out what happened. And they have found out what happened. They know that the money passed through Quintado to Falaco.
Yes, Justice.
Can I just ask then on the question of attribution? There's a lot of reference to the Canadian law, but there have been several important judgments of the UK Supreme Court within the last 4 or 5 years on this question. But they make a point which seems to be consistent with our law. And I think some reference is made, am I right, to the Meridian Global Fund case as well,
yes,
in their heads of argument.
That is correct, Justice. Yes.
And the later cases in the Supreme Court in the United Kingdom builds on that by emphasizing that the question of attribution depends for what purposes you are asking the question and in what context. Now, the one context in which, as far as I am aware, one never attributes the knowledge of a delinquent person to the company is in proceedings between the delinquent person and the company. In other words, between a company and a third party, the company may be bound by what a rogue director has done. But in proceedings between the rogue director and the company, you never attribute knowledge because the company is the very party who was entitled to lawful action in accordance with fiduciary duties by the director. Would you accept that proposition?
Yes, Justice.
Can the trustees of the low insolvent estate, leaving aside any special remedies which are conferred on them by the Insolvency Act, can they have any better rights to sue Quintado than the lows themselves could have had?
I would only submit, Justice, that that insofar as they are coming to the insolvency and they do step into the shoes of the insolvent, but they come without knowledge. And as Justice has pointed out, they have extensive powers of investigation, but that the principle alluded to might not find application as far as the insolvency trustees are concerned in that case.
Okay, I don't think any has been cited in the written argument. Can you cite any authority for the proposition that outside of the statutory remedies conferred on them by the Insolvency Act, the trustees, when stepping into the shoes of the debtor, can assert a claim against another party which the debtor himself couldn't assert?
Justice, I don't have authority for that proposition at my disposal, and I certainly did not cite any.
So if Mr. Lowe himself were suing the company for repayment of an alleged loan, the company could, assuming it was in fact not authorized, and Mr. Lowe said, yes, but my knowledge is attributable to the company. That is one instance, and I don't think there can really be legal doubt about this, where the delinquent director can never say the company is fixed with my knowledge.
In that situation, yes, Justice, I have to concede that.
If I can just, well, I suppose there's not going to be time to consider the UK Supreme Court cases, so I won't give you the references. Thank you. Those were the matters I wanted to raise with you.
Thank you, Justice.
Mr. van der Merwe, does Quintado accept that if we find that Mr. Lowe had no entitlement to the money, then that's the end of the matter? We don't get to the directing minds question.
Sorry, Justice Trott, I'm just, our approach to the matter is that the directing mind issue is fundamental to understanding. I understand. Sorry, may you just repeat the question again, because I think I might have misunderstood you.
Yes, well, let's look at it with reference to Whitehead versus Dumas that you rely upon.
Yes.
if I understand your submissions, you rely on that case to contend that Mr. Lowe was entitled to the funds that he misappropriated. But in Dumas, the money was paid to Whitehead. The applicant intended to make payment to Whitehead. It's different here. Mr. Lowe's clients didn't intend to make payment to him. They were under the impression that whatever amounts they paid to him would be invested on and transferred on their behalf.
Justice Tron, we submit that we fall squarely in the Whitehead scenario of facts. In other words, when the funds were solicited from Mr. Lowe's clients, he invited them to pay the money into his account. And they knew that what they were doing. They thought he was going to use that money for investment purposes. But what they definitely knew was that they were going to pay into his account.
They paid to his account for him to use it to invest on their behalf. They were not paying to him personally. Isn't that the difference between Whitehead and our matter?
If I remember correctly, Whitehead was an attorney and it was a trust account. And we submit that the clients in that case were paying money into the trust account also for purposes of some investment, which turned out to be a fraudulent investment, if I recall the facts correctly. So I submit that there's no essential difference between the facts of this case as far as the part of the transaction is concerned between the original clients and Mr. Lowe and their payment of the money. So I submit that the facts clearly show those clients intended to pay the money into that account and the recipient intended to receive it, and that the dicta in the case of Nissen and I think Bank of Lisbon do not apply in this case, because it was done in contractual setting.
So do you maintain that even if Mr. Lowe had no entitlement to the money, which he misappropriated, that we still get to the question of directing minds?
We do maintain that, Justice Thorne, but we would submit that Mr. Lowe didn't have an entitlement to the money to misappropriate for himself. Mr. Lowe was going to invest that money, but he had the right of disposal. So we say that when the money is paid into a bank account, the holder of when the party paying intends to pay it into that account and the receiving party intends to receive it, then that party has a right of disposal. And then it does not matter that money is at that point then misappropriated or used for a fraudulent purpose. There is a right of disposal which the account holder has.
So you say the right of disposal makes the difference?
Yes, we do say that that one cannot simply ignore the legal consequences of what happens when someone pays money into a bank account. And by doing so, it would make the task of insolvency practitioners very, very difficult indeed in similar kinds of cases where they would have to try and decipher the underlying transactions without taking into account the fact that monies were paid through various accounts and following the consequences, the normal consequences of what flows from those actions.
So if I understand your submissions, Mr. van der Merwe, but you would probably also submit that on that basis, Nissen can be distinguished.
Yes, we say Nissen can be distinguished and ought to be.
In response to questions from my sister, Justice Mhlantla, you made the submission, and please correct me if I didn't hear or understand you correctly, that the High Court did not apply a flexible approach. Now, that complaint is very different to the complaint or the case to be advanced that the law needs to be developed to encompass a flexible approach.
Yes, I understand the distinction, Justice Thorne. We submit that, in fact, what Mr. Justice Binswater did was to look at Canadian dredge, apply it inflexibly, and also he applied the test itself was inflexible. So perhaps I did not express myself properly. The test applied by Mr. Justice Binswater was not flexible. And we submit that if the test is flexible, if the common law is developed to make the test flexible, to bear in mind the policy considerations and social justice issues underlying those policy considerations, then we submit that the outcome should be different.
Yes, and if I could just go where my sister Justice Mplantla referred you to paragraph 25 of the judgment. And it seems that the SCA and here JA acknowledged that the test is context specific. And if you look at line 4 of the judgment, it says, in each case, the court strives to determine whether it is the company which has spoken or acted to a particular effect through the voice or conduct of human agency and thereby to be held to the consequences. And if we go to line 24, 23, each is an example of an attribution rule for a particular purpose, tailored as it always must be to the terms and policies of the substantive rule. So it seems that our law does acknowledge a flexible test. And further, in paragraph 26 of the judgment, the last sentence of the judgment, this is Justice Binswarden speaking, I am also unable to conceive of any reason in legal policy why, in the particular facts and circumstances of the case, Lowe's fraudulent action should be attributed to the respondent. Now, there's two separate questions, Mr. van der Merwe. It seems that our law does embrace a flexible test. It does embrace a test where policy must be had regard to, and that's acknowledged by Justice Binswarden. But if I understand your argument, you say that he did not apply a flexible approach. If our law already embraces a flexible standard, then it does not need to be developed. Then it may well be, if you are correct, that Justice Binsward misapplied the test.
Yes, Justice, I understand the issue. Our submission remains that the test itself needs to be flexible, whereas what those dicta we're referring to in our respectful submission is that there are a number of different factors that may affect the outcome when measured against the strict Canadian dredge test. And that is the approach we submit that Justice Binsward had taken in the judgment and with reference to the various passages. So our emphasis is different. We say that the test should be flexible. It shouldn't be rigidly applied, or rather the test should not be rigid, even though different factual circumstances can present themselves. On a rigid, if the test remains rigid, then it's simply almost a tick box approach by looking at each of the phases and what is the evidence? Does the evidence comply with this part of the test or not? Tick. Does the evidence comply with the second leg of the tick? And that's what Mr. Justice Binsward did in our submission, and that's the incorrect, and we say that's incorrect. If the test
I understand your submission, Mr. van der Merwe, and I think in your position, you cannot make the concession that it's not, because then you don't get through the door with jurisdiction.
I understand that, Justice. I think there was a second part to your question, and that is what policy considerations. We submit that the similar policy considerations as would arise in where are the boundaries to be drawn between a director's, between the company's, the company not being held liable for actions of its directors. And it seems in this type of case, it seems to us that if Mr. Lowe was an employee, maybe a manager of the company, a strong case could be made out that the company would be held vicariously liable. But on the same breath, because he's a director, the company suddenly, his conduct's not attributed. That result we submit would be, on the face of it, anomalous. There are policy considerations why that should not be so, and there are important policy considerations. Companies should be held liable for the aberrative conduct of their directors, unless there are good grounds not to hold them liable. Because to enable directors in these circumstances to at least to argue that the company should not be liable, we submit prevents the proper justice in given situations. And we submit this is one of those kinds of situations where justice is not given effectively. But by analogy, the test for attribution should not be more stringent than the test for vicarious liability, for example, where a company employee's conduct in that situation where a company would be vicariously liable. But when it comes to a director of the companies, the director's conduct is not attributed to the company. We submit that gives rise to a wrong result. And we also make the alternative submission in our heads of argument that the same points raise important legal points or arguable points of law. I do not wish to.
I'm so sorry, Mr. Van der Merwe. I had one last question which I had forgotten about. The request that the common law should be developed, that's being raised for the first time in this court, is it not?
I think we did say that in our application, Justice, that section 39(2) is engaged. Yes, sorry, I mean, it wasn't raised in the previous court, yes, sorry. That's correct.
Are there any special reasons or any reasons at all why that question was not raised before and why this court, sitting as a court of first and last instance, should deal with that matter?
Justice, I cannot unfortunately speak for the representation of the insolvency trustees in the earlier courts. I did not represent them in those courts. Nevertheless, it seems to me that at that stage, the issues that were raised in those courts were not considered from a constitutional perspective. And that must be the reason why it was not raised in the previous courts. But where the constitutional issues do arise and where there might be anomalous results and policy considerations apply, we submit this court can be engaged on that basis.
Yes, I think we have actually held to the contrary in Tiki Dry.
We do refer to Tiki Dry in our heads of argument, Justice. I would hope that Tiki Dry supports our contentions, but we refer to it in our heads of argument, yes.
Thank you, Mr. Van der Merwe.
Mr. Van der Merwe, just one aspect. What is your cause of action here? Are you relying on an enrichment claim?
Yes, Justice Malik.
Now, what does attribution, the doctrine of attribution, have to do with that simple legal principle?
The doctrine of attribution simply
yes.
requires.
How does that affect what we have before us, applying those principles onto the facts of this case? Enrichment principles.
What Mr. Justice Binsward found was if the conduct of Mr. Lowe cannot be attributed to the company, then there's simply no basis upon which the claims lie in the hands of the insolvency or against Quintado. We submit that the basis upon which this should be held to have occurred is that payments were made into the bank accounts, and it is that fundamental issue which we submit means that the attribution of the company to the conduct, that the conduct of Mr. Lowe should be attributed to the company, and that the company should be held to have had knowledge of and be responsible for the conduct of Mr. Lowe. We submit that is central to the outcome in this matter and the decision of Mr. Justice Binsward, that all the money simply passed through as a conduit, and they literally did not touch sides, and that they ended up only in Falaco with Quintado with no legal effect, in other words, between the passage of money into Quintado's bank accounts and out again.
Well, on first principles, how was Mr. Lowe impoverished? This wasn't his own money. He was stealing investors' money. How was he impoverished? How was his estate reduced?
His estate was reduced.
As you respond, the 45 minutes is up, but please do respond.
Well, we submit that once the money is passed from Mr. Lowe's accounts to Quintado, his estate is reduced in the sense that those monies are no longer available or at his disposal, as is the recipient of the money enriched because the money is now in the bank account of the recipient, we submit.
But he was a thief.
Yes.
He was stealing clients' money. How does he get impoverished by paying money over to Quintado if he was a thief?
Justice, I think we cite one of the cases in which, if I can just bear with me for a second, I think in Absa Bank versus Moore, which is a decision of this court, was held that even a thief who pays debts, paragraph 35, Mr. Justice Cameron held that indeed a thief who pays her own debts with stolen funds extinguishes those debts, provided the creditor who receives and accepts payment is innocent. So that's the principle we submit would apply.
Right. Let's move on. Quintado. Quintado was a pipeline. It was just for the funds to flow through to end up in Folaco, which was Mr. Lowe's company, from which he disbursed funds further for settlement of his debts and other uses. So how was Quintado enriched?
Justice Majid, that's where we do take issue with the judgment of the court of quo.
I know you take issue, that's why you're here, but I mean, how were they enriched?
May I just address the pipeline issue, because that will also address at the same time the enrichment issue. The word conduit is often used, and it was liberally used in the judgment, but we submit that there's nothing exceptional clings to the word conduit, and in fact it hasn't acquired a particular legal significance.
Let's use the word pipeline.
Even pipeline, we submit that once a bank account is used, it has consequences. And even if the perpetrator ultimately intended to move the money on, I mean, it almost happens on a daily basis that we use our bank accounts, we put money in, we are going to intend to move it on. At what point must the perpetrator be heard to be able to say, but I never intended the money to sit in that account for longer than, and for how long, for that matter, before it has legal consequences? The issue here was there was an action instituted where 5 payments emanating from Mr. Kellerman, who loaned funds to Mr. Lowe, were made into the account, and almost immediately those exact amounts were passed on. But for the rest, it can hardly be contended that this was purely a pipeline situation. There were monies coming in for legitimate farming purposes or expended on legitimate farming expenses, for example. And while money was coming in over a very long period of time, several years, that money was mixing with other money. So the sources of the money in this case, or perhaps I can put it this way, the account of Quintado was not solely used to channel Mr. Lowe's clients' investment funds through towards Folaco. It was used for many, many other purposes. And the principle of commixtio would mean that this account was not used purely as a pipeline, even if some of the money, even if Mr. Lowe intended to move some of that money on to Folaco eventually. We submit that quite clearly on the facts of this case, commixtio does address that problem.
Well, just a last question then. Is there anything in law precluding the trustees, your clients, from proceeding against Folaco?
Well,
or is the money gone?
The money is gone. There's nothing.
Yes, but now in law, that's on the facts. In the law,
yes.
Was there anything precluding them from proceeding against Folaco?
Well, no, except that what liquidators would do, or insolvency trustees, is look where the money went in terms of the flow. What bank accounts were they paid into, and that would be the recipient of the funds. Applying ordinary legal principles, once one acknowledges that you cannot just ignore the fact that money was paid into a bank account, it has legal consequences, then the liquidator's claim would actually lie against Quintado. If the liquidators had, for some reason, decided, oh, we need to sue Falaco, or we need to reclaim the funds from Falaco, Falaco's first line of defense would be, but what cause of action or connection is there between them? The liquidators have to somehow try and prove the link between the funds, the original funds, and ending up in Falaco. We submit that would make the task of insolvency practitioners or liquidators such as these impossible on the facts of this kind of case. Consequences should flow from paying money into bank accounts. Thank you, Justice.
Well, how much more time do you want?
Justice, if I may just be permitted to consider my heads of argument for a second. I do not intend, perhaps another 2 minutes. Thank you very much. As to the point of law, we submit the same considerations arise and as to whether constitutional issues raised, and I don't wish to retraverse the arguments already made. We also deal with certain factual issues in our heads of argument, which I do not wish to address your justices directly on. Those are set out in our heads of argument. We do make the point that Quintado did benefit from payments through the farming operations and through payments of various legitimate farming expenses. The judgments and the findings of Mr. Justice Binsward were we submit clearly incorrect as far as that is concerned, also with regard to the knowledge of Mr. Kellerman. And then lastly, which was a question which Justice Majid had directed to me, question of the conduit issue, we submit was also incorrectly found also in relation to the facts. I have made submissions as to the impact of this matter on the HMP trust matter, and we submit that this finding either in our favor on the application for leave to appeal or against us in this matter will not have an impact on the HMP trust case. And we make that submission in our heads of argument in paragraphs 120 to 124. In conclusion, therefore, the applicants pray for an order that firstly condemnation be granted, that leave to appeal be granted, and that the appeal is upheld, and that the orders granted by both the Court of First Instance and the Supreme Court of Appeal are set aside, and that Quintado is placed in final liquidation. And that costs will then be costs in the liquidation, as the court pleases.
Thank you, Mr. van der Merwe. Mr. van Eerden.
Thank you, Justice. Just as a starting point, the one thing that must be borne in mind at all times is that this is an instance of the trustees having stepped into the shoes of Mr. Lowe. This is not an instance of the cause of action being under the Insolvency Act in relation to a disposition. In other words, whether Mr. Lowe had a claim against Quintado or has a claim against Quintado is the question before the court. And we say, firstly, that with regard to the court's jurisdiction, we say that issues with regard to attribution don't arise in this matter because on the version of the applicants, there is no enrichment of Mr. Lowe. There's no enrichment of Quintado, and there's no impoverishment of Mr. Lowe. And we point out in our heads of argument extensively why we say so, because they put up the case themselves. They say that the funds that came into the account of Quintado, some 31 million rands, some of those funds flowed back, 17 million rands, and what was left with 13,686. They then say, when in answer to the affidavit of in the replying affidavit, in answer to the affidavit of Mr. Kellerman, where he contends that the money that flowed to Quintado was disbursed on behalf of Mr. Lowe, also, in fact, flowed to Falaco. They say, yes, that 14 million rands, indeed, some of that money is the same money as which net, in a net sense, flowed to Quintado. And accordingly, that forms part of the loan claim against the HNP Trust. That being so, we submit, first of all, that this claim is nothing other than the same claim which has been advanced against the HNP Trust by the State Lowe. It's the same claim, and one cannot, under those circumstances, have both claims we submit. They have proceeded to enforce or purport to enforce the claim against the HNP Trust, including the amount that has been disbursed to Falaco, and they have, in other words, in this instance, not been impoverished, because their claim, they say, is against the HNP Trust in relation to the funds that were disbursed via Quintado, the net amount. So firstly, we say in this matter, you don't have to look at the issue of attribution, because they don't get out of the starting blocks with regard to the facts in relation to the issue of enrichment. We set out all of that in great detail in our submissions, and it starts at paragraph 33, in fact, in 31, and it carries on up to paragraph 42. What they say when they admit that they asserted the fact that Mr. Lowe enjoys claims against the HNP Trust does not mean Mr. Lowe does not have a claim against Quintado in respect of the same money, as Mr. Lowe and Quintado colluded to dispose of the property of Mr. Lowe. They clearly accept that there was no benefit to Quintado, as they stated. It is not a requirement that there should be any benefit from this transaction. And they then say that they rely on the Actio Poliana. Now, we say it's clear from their own version in their replying affidavits in this matter, and that's the first set of replying affidavits, that their claim cannot succeed because they have conceded that that claim is a duplication of the claim against the HNP Trust. And they contend that that claim is good. We say, of course, in the HNP Trust matter that the claim against the HNP Trust is in fact not good, but it should be a claim between the Lowe's estate directly against Falaco. But be that as it may, no impoverishment can be shown under such factual circumstances on the version of the applicants themselves, we say. But as we contend further, we refer to, in our heads of argument, particularly to the facts in order to show that the cause of action relied on by the applicants, I apologize, by the applicants is nothing other than they call it an enrichment action, but under the circumstances which appear clearly from the facts, it is in fact a claim which should have been directed, we say, against Falaco if there was a claim. That is so because of the fact that the account of Quintado was used as a conduit. And we say that even if you were to attribute the intention of Mr. Lowe to Quintado, the effect would be the same, because Mr. Lowe's intention was to take the money from his investors out of his account and hide it by investing it on his own behalf in Falaco. The way he would hide it is by laundering the money through the account of Quintado. In other words, wearing his hat, if he was wearing such hat, wearing his hat as Quintado, his intention was never that Quintado would use that money for its own benefit, but that it would be laundered through the account of Quintado and end up at Falaco. In other words, Mr. Lowe, who is the plaintiff, effectively in this matter, if there was an action, Mr. Lowe, the person who colluded with himself is the allegation. Mr. Lowe is now trying to claim from Quintado the money which he transferred to Quintado in order to transfer it on in fraud of his investors to Falaco. Now, as his lordship, as Justice Rogers pointed out to my learned friend, the difficulty, of course, is further that when one gets to, and if one gets to the claim, the issue of attribution, the one instance where you can never attribute the actions of a delinquent directed to the company is where he is the plaintiff. He is the perpetrator of the fraud. He is the socius criminis in respect of the actions that he purported to perform. In the circumstances of this matter, Mr. Lowe must now be held to have a claim against Quintado under circumstances where he defrauded his investors and fraudulently laundered the money through Quintado's account. Now, what possible rule of policy could we submit, make a court change the rules of attribution in order to accommodate such a claim? When we're talking, my learned friend talks about vicarious liability and he says the rules should be the same. Well, that's a strange suggestion to say the least. So under circumstances like these, if Mr. Lowe was an employee and he had misused the account of Quintado to launder money for his own benefit, the effect of that would be that the employee would then be able to sue the company whose account he misused in order to return the money that he'd stolen. Now, we submit that there's simply no basis on which my learned friend could persuade anyone that the circumstances of this case would necessitate the changing of the rules of attribution in order to enable him to do that. We submit.
The 10 minutes is up. Still need more time?
Yes, Arud. May I carry on until interrupted, Justice?
No. Let's decide on how much more.
I am happy to. I can deal, I think, just briefly with some issues in 15 minutes. 20 minutes.
20, no.
15 to 20 minutes.
No. At the most, I'll give you 10.
Right. I shall proceed. Just to consider what we raise in our heads of argument, then we submit, firstly, that the court does not have to consider the issue of attribution at all because there is no case for enrichment. In fact, a case for impoverishment doesn't exist on the admitted facts. We say that the difficulties that the applicant has, is that Mr. Lowe can never have a claim either on the basis that of his own intention, or even if his intention was attributed to Quintado. But we say that his intention cannot be attributed to Quintado in any event, because we say that the flexible rule which was applied by the quota quo with regard to attribution could never have resulted on the facts of this matter, on policy or otherwise, in holding Quintado liable or in finding that Quintado was in fact the beneficiary of the payment that went through its account, the fraudulent, and one may add perhaps and money laundering payments that went through its account. Now, with regard to the particular facts, we set those out in paragraph 23, and we say that there's no need to engage the court with regard to the so-called constitutional issue, nor is there any need to engage the court with regard to development of the attribution test. But we say that in any event, any attribution test as developed is never going to apply under circumstances such as these. I am inclined to agree with the contention that His Lordship, Mr. Justice Vince Ward, may have misapplied the Dumas case, and that the money in the account of Mr. Lowe, well, he was entitled to disburse that money at the time when he received it from his investors. That, however, means that Mr. Lowe, the only thing it means is Mr. Lowe could be a plaintiff in an action or an applicant, but against whom is the question. Mr. Lowe has not made out a case for his own impoverishment because of the duplication of claims, and he's not made out a case.
Mr. Van Heerden, it sounds like you are arguing from, the main argument from the beginning now. Are you replying to specific issues that Mr. Van der Merwe argued? It sounds like you are arguing. It's your main argument now.
Justice, I haven't had an opportunity to make my main argument, so I think that's what I am entitled to do, I would suggest. Oh,
gosh. He's the respondent here.
So if you would allow me to do a little bit more of that, I will be a much... Now,
my most sincere apologies, Mr. But still, your original time is up. Your original. I gave you 10 more.
As you please.
Yes. Please go on, Mr. Van der Merwe.
Van Heerden,
Mr. Van Heerden.
We say, particularly at paragraph 70 of our written argument, that it is manifestly not in the public interest to, in this case, apply or change the rules as announced in Canadian Dredge, and there's no reason to do so. And as pointed out in the argument of my learned friend, the rules are already flexible, but under the circumstances of this matter, we say there can be no basis to change the rules or apply the rules differently under circumstances where the very person who is the plaintiff is the person who is the author and criminal mind, who had, under the circumstances, planned and executed his plan. His plan was to put his money, which wasn't his money originally, to put the money into Falaco to his benefit. That plan is precisely what he attained. Under the circumstances, to say that he should now have a claim against Quintado is simply not in accordance with justice, and is certainly not manifestly unjust, is not manifestly just. It is in fact the opposite. In fact, we refer in paragraph 74 of our heads to certain authorities where these kind of issues of attribution occur. And in a case such as Kritzinger, it's often the case that the court was seized with the question of whether there was criminal liability to be attached to a particular party, and et cetera, et cetera. Now, Kritzinger's case, we submit, is something that should be considered, and together with the case of Klein versus Colossus, because those cases demonstrate the reason why the rule is what it is, together with the judgment of His Lordship Justice van Rensburg in the Canadian case that's referred to by my little friend.
Mr. Van Heerden, let me apologize to you most profusely. I guess because I had heard your voice before, I literally got my wires crossed. I apologize most profusely. I don't know how my mind suddenly thought that you were replying. It's your main argument. I feel terrible about the mistake I made. My apologies. When I came in, it was the 10 minutes that was up. And I should have said, my colleagues may then ask you questions. I hope and pray that you have forgiven me.
I forgive easily.
Thank you.
I was making the point that these cases that were referred to in paragraph 74 of our written submissions demonstrate what the reason is for this rule. In the case of Colossus, for example, there was an issue of prescription. Now, what would happen particularly is that a certain unlawful deed would be executed on behalf of the company purportedly by its directors. In the case, and at some stage, those directors are not in control of the company anymore. Now the company needs to rectify the situation. The only way in which a company can do that, even if it's more than the prescription period, is by saying that the company as such, as it's referred to, the company as such cannot be awarded or cannot be held to have had the knowledge of the offending directors at the time when the unlawful action occurred. And that is where the rule finds its application. It's to protect a company against its own rogue directors under circumstances where the company shouldn't be held liable, shouldn't be held accountable for their rogue actions. And the criteria which have been set out in the Canadian dredge case are, we submit, particularly apposite, and is a good and effective test to consider under circumstances where these events happen. Now, there are certain assertions made about Mr. Lowe and that he acted within the that he was the person who was the directing mind, and that he acted inside his activities that allocated to him. That can never be correct, we submit. Mr. Lowe, the company had two legitimate activities. It was a property owning company, and the directors had agreed that Mr. Lowe could farm. Certainly, there was never any basis upon which this company could engage in money laundering, which is what Mr. Lowe was engaged in. And further, there's no way that this company that there's any relevance in the fact that there were also by Mr. Lowe certain fraudulent transactions in relation to tax that was conducted. Mr. Lowe was not authorized, and the company was not in the business of doing tax schemes for its customers. So, but in any event, of course, we're not talking here about any of those tax schemes. We're talking about the question of whether we can attribute to the company Mr. Lowe's conduct in laundering the funds through the account of Quintado. Was it ever the intention, in other words, the attributed intention of the company, Quintado, to receive the funds on its own behalf and to use it? My learned friend says, well, other debts were paid, but of course, that doesn't take into account the fact that there are distinct operational issues in relation to this company, and that Mr. Kellerman was able, when he did his calculations of whichever funds were still owing to the Lowes and with which funds were eventually paid over, he was able to distinguish the different activities of the company. And one of the activities of the company that is easily distinguishable is when money is received from Mr. Lowe, that money, those funds are the funds that end up mostly in Quintado in one respect, and in other respect, they are the legitimate farming operations, which are dealt with differently. And of course, the invoices would be different, and the expenses would be different. And then there are these VAT fraud transactions, which are also different and which have a completely different beneficiaries, so to speak, being people who wanted some relief on the period when they're supposed to pay over their tax to the receiver. Under those circumstances, we submitted that it is clear that Mr. Lowe's scheme, first of all, cannot be attributed to the company because it wasn't acting within any business or any course of business of the company. But in any event, even if the rules of attribution were changed to such an extent that Mr. Lowe's intention was attributed to the company, his intention was never that Quintado would benefit from the funds. And if, as matters stand, what happened, Quintado didn't benefit from the funds because the outcome of it all was that Quintado has no claims or no further assets or no enrichment as a result of it. What happened, Mr. Lowe was also not impoverished because he has a claim against the HNP Trust. And in any event, he has, we say in the alternative, a claim against Falaco by virtue of these transactions. So we submit that under those circumstances, the court, a quote, correctly held that although we contend that perhaps the court erred with regard to the Dumas principle, we say that the court correctly held that the intention of Mr. Lowe or the actions of Mr. Lowe could not be attributed to Quintado in the sense that Quintado wanted to benefit or did benefit from the funds. And in any event, even if his intentions were attributed to Quintado, we say that that means that there is no claim against Quintado because his intentions and his actions were directed at laundering the money through Quintado's account and for the money to end up in Falaco. We deal in our submissions with the factual issues, and we submitted those are correctly dealt with, and we submit that on the facts of the matter, it is so that the impact of this case on the HNP Trust matter, or the other way around, is that it is clear, if one has regard to both these matters, that the claim in the HNP Trust is a duplication of the claim in this matter. That is on the version of the respondents and of the applicants themselves. And we say that it is fatal to any cause of action, whether it is, and in particular, an enrichment claim. May I just have a moment and those are our submissions, and we submit that the application should be dismissed for all the reasons that we've set out, and that the cost should be paid by the applicants, including the costs of due counsel. We also do not oppose the application for condonation.
Thank you, Mr. Van Eeden. Done well within time. Thank you very much. Thank you. Mr. Van der Merwe.
Thank you, Justice. Justice, I wish to only respond to 2 points. The first arises out of the questioning and the reference to the Tiki Drive case. We submit that this court's jurisdiction was engaged in Tiki Drive based on what it described as exceptional circumstances in that case. And we submit by analogy, in this case, exceptional circumstances do exist. And the exceptional of those circumstances in this case would be the exceptional injustice that would arise, and that does arise, with regard to the application of the inflexible Canadian dredge test to the facts of the case. That would in turn leave the victims, and even though the claims lie in the hands of the insolvency practitioners, it would leave the victims of Mr. Lowe's fraud effectively without a recovery remedy on the facts of this case. And we submit that those are exceptional circumstances. That result also implicates issues of access to justice, and we submit that Section 34 of the Constitution is in fact engaged where effective access to justice is denied to those victims. The second point I wish to make in apply is with regard to the duplication argument, the duplication of claims argument. In this case, the flow, in common cause, the flow of funds, some 31 million rand flowed to the bank account of Quintado from Mr. Lowe's account, and 17 odd million rand flowed back. Hence, the claim that was formulated on the first alternative basis in the court of quo, but which is the one that we still pursue, of 14 million rand. We submit that given that there were different parties involved, and given specifically the fact that legal consequences must flow from the payment into a bank account of those monies, that the claim is accordingly not a duplicated claim, but the claim properly lies in this case against Quintado. Secondly, even if it were so that there was an overlap of claims, that does not mean that the liquidators would not be entitled to pursue those claims. They would obviously not be entitled to recover double amounts, but pursuing the claims is within their powers, because they would need to establish, based on the relative evidence that they have at their disposal, where those claims ultimately lie. But the mere fact of duplication, we say, does not undermine the fact that the claim is there. Thirdly, as to the impact of the impact of this claim, if the claims are in fact duplicated, the final impact would ultimately only be that the claim of 62 million rand that lies in the hands of the insolvency practitioners against the HMP Trust might be reduced thereby, but it does not remove that claim. So the impact of this case is not such that it will have an effect on the outcome in the other matter as we submitted originally. Those are our submissions. Thank you, Justice.
Thank you, Mr. van der Merwe. Thank you to both counsel. Judgment is reserved. Court adjourned.
Oh, please.
Today's proceedings have concluded. The host will now terminate the meeting.